Okay, good afternoon, everybody. I'd like to call. I'm trying to. There we go. Let's try that again. Good afternoon, everyone. I'd like to call to order the March 28th, 2024 meeting of the Judiciary Committee, and we will now take a recess. You're welcome.
I'll just hit that. What? Okay. Robin, I know you. I know. He's like, yes, he does. That was the most. I never, and you just happen to see that one. First, I was always right to get it. I generally don't pop up. Yeah, yeah. Yes, yeah, that's the movie. Yes, that is, yeah, and you got that wrong. I was right. I wasn't. And again, the thing is, like, I can appreciate that ball, but when a ref doesn't make ball, things are down. Is that like dark gray or is it like very calm? It's a what calm. Okay. Like what?
Hello. All right, good afternoon. Welcome back. We are going to reconvene the Judiciary Committee for today, Thursday, March the 28th. Any comments from my co-chair? None. Ranking members? None. We will jump right into the agenda. Roman numeral number 3, bills for possible JF. We have as the first bill, Senate Bill number 4, an act concerning victims of domestic violence, the unsolicited transmission of intimate images by means of an electronic communication device, and impermissible use of non-disclosure agreements in the workplace. The motion would be for a JFS, which is LCO 3543. Is there a motion?
So moved.
Moved by Representative Porter, seconded by Senator Flexer. Is there discussion? Senator Kissel.
Thank you very much, Chairman Winfield. I'm going to very reluctantly vote no at this time to flag this bill, with the full hope that when it finally gets fully in its final form, I'm going to be able to support it in the Senate. I think it's got really laudable goals. I think as everyone on this committee is aware that I always look forward to working with Senator Flexer on any issues regarding domestic violence. And I do believe that Connecticut is, if not the leading nation in the country when it comes to addressing these issues, one of the leading states in the nation. I think there's other areas here that are extremely important. I think we have a good debate coming down the road regarding, God bless you, non-disclosure agreements and whether they benefit or don't benefit victims of sexual assault and related matters. And I certainly heard very important testimony when we heard from folks regarding some of these issues. So I have the utmost hope for this bill of crossing the finish line with strong bipartisan support. But at this time, I'm going to vote no just to flag it for those reasons that I just stated. Thank you very much, Chairman Winfield.
Thank you, Senator Kessel. Representative Fishbine.
Thank you, Mr. Chairman. Mr. Chairman, some questions and comments. I'll start with a comment. I know in line 21 that we are preventing actions by 18-year-olds. And I know that I try and prevent actions by 19-year-olds, and that's met with opposition. So I'm just trying to figure out why we are, kids make a lot of mistakes, right? And in line 21 through line 35, we are expressly preventing an electronic communication between an 18-year-old to a 19 or higher year old. Is that accurate for you?
Thank you, Representative Senator Flexer. Sorry, Senator Flexer. We'll be responding to questions. Senator Flexer.
Through you, Mr. Chair, yes, in line 21, it details that this provision applies for a person who is 18 years of age or older.
Representative Fishbone.
Thank you, Mr. Chairman. Well, it seems though that, okay, so it could be 18-year-old to 18-year-old, and bringing us into line 26, we have the clause expressly forbidden, which expressly usually means in legal parlance that it is written. What is required? Because I didn't see that clause defined in this legislation by expressly prohibited.
Senator Flexer.
Through you, Mr. Chair, it's my understanding that if a term like the one the good representative asks about, expressly forbidden, is not explicitly defined in the statute, then one could take the definition of the combination of expressly and forbidden as is generally understood.
Representative Fishbone.
Thank you, Mr. Chairman. So am I to understand that it could be that a forbidden communication is okay under this language? However, one that is that forbids in writing is what is required to be bad under this language through you?
Senator Fluxer.
Through you, Mr. Chair, I would not limit this term expressly forbidden to just being in writing. I think someone could forbid the receipt of these kinds of materials in a number of different ways, and it wouldn't just be limited to written.
Representative Fishbone.
Thank you, Mr. Chairman. I'm just trying to figure out, because certainly when we make an 18-year-old liable for some bad act, I think it would be important if we knew whether or not, I mean, expressly is an adjective modifying forbidden. And I'm just trying to figure out, what do we mean by expressly forbidden? I mean, sometimes you mean that it's stressed. Many times in the law, we mean that it's written, but I'm hearing that it doesn't have to be in writing. So in what way would one let the other 18-year-old know that their action is potentially bad through you?
Senator Fluxer.
Thank you. Through you, Mr. Chair, under this provision, anyone who is over the age of 18 who engaged in this type of behavior and was forbidden, that expressly forbidden provision, I think, would apply in a number of different ways. So you could send a text message saying, don't send me these kinds of things. You could send an email. You could have a phone call where you make it clear that you don't want to receive these types of materials. You could also perhaps be in a large group of people and you say to the offending person who's sending you these images, please don't send me these things. And there are other people who see you make that clear communication that you do not want to receive these kinds of materials. So, Mr. Chair, I think that this term covers a variety of ways for an individual to make it clear that they do not want to be in receipt of these types of communications.
Representative Fishbone.
Thank you, Mr. Chairman. I think that's part of the problem, is that for one to be held to a standard, as I mentioned before, 18-year-olds do a lot of bad stuff, right? And now it could have been allegedly conveyed over a phone call, or it could have been amongst a group of people that was expressly forbidden. It becomes very problematic for a lot of these kids. So moving on to line 28, we have the clause actual damages. What would be the damages calculation, or what would come before whoever is to decide the damages in order to ascertain what the actual damages were for receipt of this communication through you?
Senator Fluxer.
Through you, Mr. Chair. So the damages would be determined by the court, and perhaps someone could demonstrate harm in terms of that image causing a limitation in the person's ability to earn money. Perhaps it would cause damage that caused them to seek medical care in order to deal with that image being sent to them. There could be a variety of ways to demonstrate the actual damages that the receipt of that image caused.
Representative Fishbone.
Thank you, Mr. Chairman. So would a claim for, let's say, intentional infliction of emotional distress fall within actual damages as contemplated by the language in lines 21 through 35?
Senator Fluxer.
That would be something for the court to consider.
Okay, and by what statutory authority there's no reference to that, and I know in Connecticut we have a high standard for intentional infliction of emotional distress. I don't see a statutory reference there, so I'm just, is there an actual connection to that through this language through you?
Senator Fluxer.
It's not explicitly, spelled out here, but it would be something that the court could consider. Again, the totality of the damages and the harm done.
Representative Fishbone.
Okay, thank you, Mr. Chairman. I mean, once again, another concern with this language, because as those of us who practice law in a courtroom know, at the end of a trial, judge has to charge the jury as to what the law is. And certainly, if we are unclear as to what could be claimed as a result of merely receiving this communication, I think it's problematic not only for public policy, but our system in general. I also note, Mr. Chairman, that in lines 29 through 30, there appears to be an automatic attorney's fees and cost clause, which I think by public policy, we usually modify those. You know, I think it would be fair to all concerned that one who has to defend, you know, maybe they can't prove that there was an express forbidden communication. You know, they should be entitled to attorney's fees and costs for having to defend those allegations as well. Mr. Chairman, I'd like to go to section lines 247. Well, let's start at 244. We talk about, and this is existing language as far as maintaining confidentiality of an employee's status, but all of this new language extends to employers' agents to know certain things. I would expect that would have to know because they'd have to put certain things into place so as to protect themselves from being accused of violating this. What is a employer permitted to disclose to their agents so that they know they could possibly violate this, or they can put in practice in their business protections to protect the protected party through you?
Senator Fluxa.
Through you, Mr. Chair, just so I have clarity, the good representative is asking for what the employer would need to know in advance.
Representative Fishbone.
Thank you, Mr. Chairman. No, I'm specifically talking about, we have confidentiality between the employer and the employee in the existing language, and that's lines 244 through 246. We are now extending the possibility of civil action against the employer's agents. And I'm just trying to figure out, are we now saying that outside of the employer-employee relationship, that employers' agents are also supposed to be given a copy of this confidential information that they have to keep confidential through you?
Senator Fluxa.
Thank you. Thank you, Mr. Chair, and I thank the good representative for that clarification. So I think the language here is to ensure that information is kept confidential by anyone who's acting on behalf of the employer. For example, today, many smaller organizations will use outside entities for payroll and other HR functions. So this is to ensure that those things are kept confidential if they are shared with another entity that is acting on behalf of that employer.
Representative Fishbone.
Thank you, Mr. Chairman. But I'm looking at the actual language though, and I did hear the answer. And looking at lines 247 through 250 in general, it says that an employer's agent shall not refuse to hire, employ, discriminate, or compensate, or in terms of conditions, or bar or discharge from employment. So that's more than just getting paid. Those are actions by employers' agents. So I would think in order for an employer's agent to have potential liability, they would have to know about this information so that they would protect it, so that they wouldn't utilize it in some way, shape, or form that would break the confidentiality. But I guess that's by way of comment. I've already asserted the question. Moving on to line 255, it appears that we are barring not only the requirement of a certain agreement, but merely making the request. Is that true and accurate? Through you, Mr. Chairman?
Senator Fluxa.
Through you, this would prevent both requiring that agreement be entered into, or that there be a request for an agreement at the commencement of employment.
Representative Fishbone.
Okay, so even if the employee was willing to, the employer is barred from suggesting or requesting that there be a sign off. Is that what this language says through you?
Senator Flexa.
Thank you, Mr. Chair. For clarity, what does the good representative mean by sign off?
Representative Fishbone.
Sure, if we look at lines 254 through 255, it says that an employer, which I would expect that actually they aren't the employer, they're prospective employer, is barred from requiring or requesting that a prospective current or former employee or a dependent contractor enter into a certain agreement. So I'm just reading the plain language. Am I to understand that merely suggesting, requesting, asking for one to sign off on an agreement like that is barred under this language through you?
Senator Flexa.
Thank you, Mr. Chair. Through you, yes.
Representative Fishbone.
Okay. Once again underlines my opposition to this bill. So, I mean, free people are able to contract freely as they see fit, and certainly I don't see a problem with somebody requesting because there could be compensation for that request. But anyway, line 260. What is the actual damages that one would incur as a result of a mere request through you?
Senator Flexa.
Thank you, Mr. Chair. Through you, an employee could, if they're requested or required to consider entering into one of these agreements by their employer, it may delay the start of that employment. They may need to seek outside legal counsel to review both the proposed agreement and whether or not it's in compliance with the law. So there could be a variety of expenses that accrued and would be actual damages to the employee.
Representative Fishbone.
Thank you, Mr. Chairman. I heard the answer, but it was non-responsive. It expanded. The question was whether or not a mere request, which a request can be denied. What is the damages for a mere request for you?
Senator Flexa.
Again, through you, Mr. Chair, the actual damages could include a delay in the commencement of that employment and therefore a delay in wages or compensation because the employee had to consider the request and they could potentially have to seek outside advice from other HR professionals or from legal counsel to determine whether or not that request was appropriate. So that could be an actual, those are two examples of what actual damages could be.
Representative Fishbone.
Thank you, Mr. Chairman. In the alternative to actual damages, it says $10,000. Where does that amount come from?
Senator Flexa.
Through you, Mr. Chair, that amount is consistent with other sections of similar statutes.
Representative Fishbone.
Thank you, Mr. Chairman. Can the good representative give us an example of a liquidated damages clause, $10,000 in our statutes through you?
Senator Flexa.
I'm a good senator and
Oh, I'm sorry.
it's
Yeah.
okay. And I, if given a moment, we could find that reference. Or we
Representative
can,
Fishbone.
I get, are we, okay, so you want me to go on while we're looking for that?
I think there was kind of a question implied as to whether you want to look up the similar statutes or
Well, I was just looking for a reference. I'm not aware of any statute. Maybe there's a contract provision somewhere in the world that has liquidated damages clause of $10,000, but I'm not aware of any state statute that has a liquidated damages clause of $10,000. That's what I'm looking for. So can anybody point one out? through.
Senator Flexer?
To you, think, Mr. Chair, if the committee would like to grant time for that to be found.
We can do that or do it as we're answering. How we can pause for a moment. Yes. We'll recess for a moment so that the senator can locate an answer to the question. All right, we'll come back to order. Senator Flexer.
Thank you, Mr. Chair. So there are a few similar references to statutory damages. There's one in consumer contracts. There's one in 52-560A concerning trafficking in persons. And perhaps most relatedly, there's a reference in the CHRO statutes concerning discriminatory practice. And that also has this $10,000 figure. Through you, Mr. Chair.
Representative Fishbaum.
Yeah, I'm just, if I could just have I'm looking at 52-560A, which appears to be Damages for encroachment on state, municipal, or land profit. Is that the statute that the good representative, I'm sorry, Senator, and I mean representative, I mean that we are a representative of people anyway.
We know what you mean.
I didn't mean that. The good senator, 52-560A appears to be damages for encroachment on state, municipal, or land, nonprofit land. Is that the statute that the good senator is talking about?
Senator Fluxer, is that one of the statutes you referred to?
No, it's supposed to, it's a statute concerning trafficking in persons. And the other reference is 46A-55. That references the $10,000 civil penalty again in the human rights statutes.
Representative Fishbone.
Okay, so it must be 52-560 and then, no. Well, the statutory site, I thought I heard was 52-560A, correct? Do you?
Senator Fluxer.
Yes, and the other is 46A-55.
Okay, let me look up that one because the other one was not. So 46A. 46A-55 is Commission Legal Counsel. So I don't see it in there either.
Do you, Mr. Chair, try going all the way to the end?
Okay, so I see that now. That's, so it says the court shall grant the commission its fees and costs and award the commission a civil penalty not exceeding $10,000. So that could be $1. And the question was, the language that we're actually voting on here today doesn't say this. It says, or statutory damages of $10,000. That's the distinction. So it can't be $1 in this particular situation. So, you know, I'll go on, but I think that's not congruent with our other statutes, but, and it does say whichever is more. So that means if someone is requested and they want to get, let's say, legal advice to whether or not they should sign this, and let's say they do pay a lawyer, and let's say it costs them $400 for an hour's worth of time to review a contract, their actual damages are $400. Okay, and maybe let's say a day off from work, because we did hear the good senator talk about that it may delay the employment. So we'll say the total actual damages are approximately $1,000. Under this particular language that we're voting on, it doesn't matter that the actual damages were $1,000. It expressly says in line 260 through 261, says actual damages or statutory damages of $10,000, whichever is more. So it doesn't matter the actual damages are $1,000. It's automatically $10,000. I don't think that's good public policy, and that does not fall in line with any other statute that I'm aware of in this state. Mr. Chairman, the last area is on lines 337 to 338. Has to do with, it prohibits disparagement or disclosure. And I'm trying to figure out, I mean, I can understand the bar on disclosure, but if the agreement says you shall not disparage your employer, why? Because it says or, it's not and. So we are barring an agreement that says you shall not disparage your employer. Why is that being sought through this legislation, through you?
Senator Fluxon.
Thank you, Mr. Chair. Mr. Chair, with your indulgence, I appreciate the representative's question and I'm happy to answer it. And I just want to express regret that before the debate on this bill started, I didn't have the opportunity to explain the broad strokes of the public policy that we're debating here. But I'm really grateful for this particular question because I think this gets to some of the main impetus for the proposal before us. So the reason this language makes it clear that there's a prohibition on both disclosure and disparagement is because that is responding to the public policy challenge that this bill is seeking to address. So as many people heard in the public hearing and as we've debated in this committee, that thousands of employees across this country are subject to non-disclosure and non-disparagement agreements. 1/3 of American workers sign those agreements the day they start employment. And in other states where they have attempted to ban NDAs using the very strict definition of just disclosure, so non-disclosure agreements, what has happened is instead employers have shifted to non-disparagement agreements. And so the reason this language here today covers both is an attempt to have a strong law like they have in a handful of other states that prevents that bait and switch, if you will, from employers being able to say, yeah, we don't have non-disclosure agreements, but they instead have non-disparagement agreements. So this is an attempt to ensure that employees who suffer discrimination in the workplace aren't being silenced the day they start on the job, and that they can't be subject to agreements that silence them and make them unable to ever talk about the discrimination that they endured in that workplace moving forward for in perpetuity, for forever. And that's what many of these agreements do. And so that's the reason why this language before us covers both disparagement and disclosure. It's to make sure that in attempting to do something, we're not just creating a workaround where employees can continue to be silenced.
Thank you, Senator. Representative Fishbone.
Thank you, Mr. Chairman. Some days I do feel I'm back in the Labor Committee where they think that all business owners are bad people, but I don't see a disparagement versus disclosure situation here. I think what's looking to be protected is the disclosure. And I'm certainly not in favor of, bad actions in the employment sphere. But to bar disparagement or disclosure would bar a statement that is not surrounded by the bad act. Disparagement of, let's say, McDonald's. They have spoiled ketchup there. That's disparaging the employer. It doesn't go to the heart of what has been represented as being protected here. So I understand the nuanced distinction, and I'm just concerned about a provision that prevents one from making up things that don't fall within the sphere of sexual harassment or something else, merely to get a benefit and yet are unevenly protected, is not good public policy here. So I think that SB4 needs an awful lot of work. Certainly I think the beginning section, expanding those programs to other judicial branches makes sense. To even out due process in those particular judicial areas. But a lot of this is anti-business owner. The entrepreneurs and risk takers that actually open businesses in this state should be able to do so. And certainly we do have legal actions to protect those that are victims of employment bad acts. So thank you, Mr. Chairman. I intend to vote against this bill.
Thank you, Representative Fishbone. Comment question from other members of the committee. Representative Trubisky.
Thank you, Mr. Chair. Question for the proponent, if I may, through you.
Yes.
In the first section, the definition of intimate image talks about an image of a person 18 years of age or older who's in a state of undress so as to expose such person's genitals. Does that include breasts through you?
Senator Fluxer.
Through you, Mr. Chair, is the good representative actually referring to section 2?
Representative Trubisky.
I'm referring to, I believe this is the current version, line 17 through 20.
Senator Fluxer.
Thank
that
you.
right?
Yes, line 17 through 20 actually are in section 2 of the bill, not section 1, and no, it does not.
Representative Trubisky.
Okay, so okay, could I ask why it does not through you?
Senator Fluxer.
Because the body part the good representative named is not a genital.
Representative Fluxer.
Thank you, Mr. Chairman. Could I ask why that portion of the anatomy was excluded from the definition of intimate image through you?
Senator Fluxer.
The goal of this proposal before us is to address the unsolicited images that covers a state of undress, as it details in lines 19 and 20, a state of undress to expose such person's genitals only. That is the concern that many people have had, and that other states have enacted similar public policy to prevent the unsolicited and frankly the what has become for many people, young people in particular, the regular exposure to these kinds of images, that there is a constant delivery of these kinds of images that are unsolicited and offensive. And so the goal here is to prevent that kind of exposure and not to limit exposure concerning or photos concerning other parts of the body.
Representative Trubisky.
Thank you, Mr. Chairman. And it just seems odd to me that we would say that a person 18 years of age or older could send unsolicited visual photographic reproductions of that person with nothing but a fig leaf continually, and that would not be covered by this. It seems to me that it's an odd exclusion that we're only defining intimate image to include one portion of the intimate portions of a person's body and not all of them. Have there not been any instances, or is this a conscious decision to exclude those types of images through you?
Senator Fluxer.
Through you, again, the advocates for this proposal are concerned about the explicit images of an individual's genitals and not concerned with other parts of the body. I would also add to this conversation that other parts of the body are are not limited to their public exposure in other areas of the statute. We can get into a detailed conversation about why that is, if that's appropriate at this time. But this policy has been brought forward to us because there is concern about the use of images in these particular parts of the body.
Representative Dubisky.
Thank you, Mr. Chairman. I thank the proponent.
Representative Fishbein for the second time.
Thank you, Mr. Chairman. So I'm just trying to drill down on that one. So if an 18-year-old communicates, 18-year-old male communicates to an 18-year-old female in writing, has it served by a marshal, perhaps gets a court order, do not send me images of your breasts. That is not barred. But if you change the scenario and it's a female who communicates to the male, do not send me images of your nether regions, that is actionable. Through you?
Representative Fishbein, in answer to your question, it is not prohibited by that. Similarly, as if we made an analysis that was relatively equal, we talk about the male continuing to send his chest pictures and the woman sending her breast pictures. This only deals with genitals. It doesn't deal with anything else, but as I suspect that this bill is moving forward, if you want to enter that conversation, we can enter that conversation.
Yeah, I just find that, we hear about the proponents, right? Which I have to assume is those somewhere else. And, certainly I think if someone walked into the LOB today, a female walked into the LOB and didn't have their shirt on, some individuals may find that to be unacceptable, as opposed to perhaps a male walking in the building. And I'm not saying that that's correct, but I think public policy wise, or, what we generally see, I think, I don't know. I just think the dynamic is interesting, to say the least. So thank you, Mr. Chairman.
Thank you. And I understand there's a lot of stigma around the breast, and perhaps we could all learn that there's a difference between that and the genitals. Representative Callahan.
Thank you, Mr. Chair. Can I just a question for the proponent of the bill, if I may, Mr. Chair?
Absolutely. Senator Fluxer, prepare yourself. Representative Callahan, frame your question.
Senator, you chose the age of 18 for this bill. I recall last year we passed out of the Judiciary Committee harmful communication with a minor. It was unanimously voted out of this committee. And once we got it to the House floor, there was some pushback from legals talking about that the age would be more appropriate at 21, I believe. I believe it was 21 or 25, but the age was moved up. I was just curious why the age of 18 on this bill was chosen.
Thank you, Representative Callahan. Senator Fluxer.
Thank you, Representative. I appreciate the question. I think the age of 18 was chosen here because, frankly, many of the people who are most frequently in receipt of these kinds of communications are younger people just above 18, 19, 20, 21 years old. But I appreciate the representative's comments about the legislation from last year and that cutoff of 21. I think there's a balance here. I think many of the people who are asking for these kinds of protections to be here in Connecticut, like they already are in other states, are of that age group. And so that's why we chose the age of 18.
Thank you. And one follow-up, Mr. Chair, if I may.
You may.
We had similar concerns with people communicating at the age of 18 through to younger children, 8, 9 years old on different apps or websites. So it was the same concerns then. yet the age was moved up once to get the bill passed through the House and the Senate. So I would just caution, I think that this is possibly a better situation for a 21-year-old age limitation, and I would prefer to see the bill written as such. That, I guess it's not a question for the good senator, it's just a follow-up comment. And thank you, Mr. Chair, for the time, and I thank the senator.
Thank you, Senator Fletcher.
Thank you. And I thank the representative for that comment as well. The one distinction I would point out here is that what we're considering here today concerns civil penalties, and the legislation that the good representative referenced from last year was a criminal penalty and a criminal statute. So that I think is a key difference in terms of the age cutoff here as well. Thank you, Mr. Chair.
Thank you.
Thank you.
Comment or question from other members? Comment or question from other members? Representative Staffstrom.
Thank you, Mr. Chair. Mr. Chair, I'm going to support this bill out of committee today, particularly because I certainly like sections 1 and 2 of this bill. I also do think it is past time that this legislature ban so-called gag orders in settlements of sexual harassment claims, which I think is probably the at least a primary driver of sections 3 and 4 of this bill. I will just note for the record, I do have reservations about sections 3 and 4 as currently drafted and the breadth of those. I think there could be some potential legal challenges to this language based on the retroactive nature to it, where we seem to be trying to invalidate existing contracts. I also think there's a question about what happens when someone works in New York and lives in Connecticut or vice versa, and how does interstate commerce play in here? That has to be worked through. And then I think kind of on the policy side, I would hate to for us to pass a very well-intentioned law that has the unintended consequence of affecting the ability of folks to negotiate severance packages. Oftentimes when someone is laid off from a job, they're offered a certain amount of severance, and they go and they fight for additional severance. And sometimes when folks achieve additional severance, a confidentiality order and a waiver of any potential claim is included in that as a way of making sure that individual gets what they've negotiated for, but is not broadened out to larger categories of employees, and that's why that person is able to achieve that additional compensation. I also think there are times that when lawsuits are settled, that one or both parties want and negotiate for confidentiality in a settlement agreement. I take an instance where someone is discharged and they believe the reason they were discharged is because their age, and maybe they're able to get their job back with back pay, but they just want to go back to work and have the incident behind them and be able to have confidentiality about whatever amount they received or the circumstances by which they went back to work. Or maybe someone has alleged race discrimination or has alleged some other form of discrimination, has gone off to a new employer and wants to be able to protect the circumstances by which they left their prior employer and how much they received as compensation in a settlement. So I guess I would caution us as we continue to look at this bill moving forward, that we make sure we're looking at potential unintended consequences that possibly could flow from, I think, what is a very laudable goal of trying to prohibit so-called gag orders in sexual harassment settlements, which certainly I do appreciate and would like to see us do. I just want to make sure we're narrow enough in the language as we move forward. Thank you, Mr. Chair.
Thank you, Chairman Staffstrom. And I would say I've had the opportunity, as have many of my colleagues, to work on several pieces of legislation with good intention. And the JF deadline is what the JF deadline is. And often we aren't at the place where we would call it completely finished. That doesn't disregard the fact that there's a lot of good work that has gone into bringing what is before us. And I will note that the opportunity of a JF deadline or a JF meeting is not just to vote up or down, but also to receive feedback that makes those bills, which we sometimes refer to as still in the process or works in progress or whatever you would like to call them, an even better bill. And I think that it is noted the concerns that are here, and those concerns will be taken into account. And the product that we have at the end will be even better than what is before us. And with that, Madam Administrator, if you call the roll, please.
Roll call vote on Senate Bill 4 to JFS it to the floor with LCO 3543. Winfield,
Winfield, in the affirmative.
Staffstrom,
Yes.
Flexer,
Yes.
Quinn,
Yes.
Kissel, Fishbein, Blumenthal,
Yes.
Callahan,
No.
Conley, Curry, Delaney,
Delaney, yes.
Dillon,
Dillon, yes.
Doucette,
Doucette, yes.
Dubitsky,
No.
Elliott, Gaston, Gilchrist, Godfrey, Paul,
No.
Harding, Hayes, Howard, Johnson,
Johnson is yes.
Khan,
Yes.
Labriola, Lesser,
Also, yes.
Mar,
Mar, yes.
Miller, O'Day,
O'Day, no.
Osborne,
Osborne, yes.
Pavlock D'Amato, Porter, Sampson, Sims,
Sims in the affirmative.
Veach,
Beach is a no.
Walker, Wilson.
Madam Administrator, I'm having technical problems. Miller, yes.
Thank you, Senator.
Thank you. And at a later time, we'll talk about whether the vote will be held open, and if so, when that will be. Have to figure out what the tenor of this meeting is. Number 2, Senate Bill number 209, an act concerning non-resident landlord registration and increasing penalties for repeat building and fire violations. Is there a motion? Yes, it's a JF. It's moved by Senator Kissel, and I think seconded by Representative Staffstrom. This bill requires the registration of information to identify those who own landlords who own certain types of properties, and it increases the penalties for building and fire code violations. Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chair, I want to thank the Housing Committee for the work that it did on this bill. You know, I do intend to support it out of committee. You know, I'm generally in favor of Section 1. I think that those absentee landlords, there should be some process and requirement that there is a registration for many reasons. I am concerned with the, you know, the increase in penalties here. You know, once again, landlords do provide a service, a needed service to many people in this state. And there are good ones and there are bad ones, as there are in any profession. You know, certainly state fire code violations are of concern. But you know, ultimately, what I see many times is some violations not being in the code, and local officials just arbitrarily making up what they think is right, prudent, what should be in the code. And presently, under our system, it appears that there is no right of review. And I think as we work forward towards the end of session, we should be looking at whether or not those sometimes arbitrary decisions by a local official, there's some right of due process through our courts. We have administrative proceedings, administrative appeals. We have due process for both sides. And I think we should be looking at those kinds of things. So, for the purposes of at least getting this out of committee and working on it further, perhaps, I do intend to support, and I thank you for the opportunity to state my position. Thank you.
Thank you, Representative. And I will say, as I said to you when that you brought that to my attention, that I will have conversation with the chairs of the Housing Committee, making them aware. I do think that the bill is itself good public policy, but that your suggestion is one that to me makes some sense, and we will see where we can go working on that in tandem. Senator Kissel.
Thank you very much, Chairman. I'm happy to support this bill out of committee at this time. And I agree with some of the concerns raised by Representative Fishbein that I guess in certain parts of our state, we have overzealous building inspectors that may go wide of the mark and be too harsh on folks for no apparent reason. But that being the case, I think one of the Achilles heels that we have as a state right now in combating poverty and again, our young people getting involved in crime is there's just certain problems in some of our communities, and it's hard to get housing up to code when the landlords are difficult to locate and they're out of state. They may be LLCs owned by other LLCs, and it's just trying to hold people accountable. And one of the things that Senate Republicans have proposed in the past is, as we address issues of crime, in particular juvenile crime, is lack of opportunity for jobs and education in certain respects, but also housing. And it's a totality of circumstances that have led to certain negative impacts throughout our society. So I think as we have fruitful discussions regarding how can we reduce violence and how can we reduce gun thefts and things like that, it would be short-sighted to say that we shouldn't also address housing disparities and getting people that should be responsible and accountable. And I think that the registration noted in the first part of this bill is critically important for us to hold those folks and those entities and those corporations and LLCs accountable. And so for that reason, I think that there's a lot of very positive value to this legislation as it moves forward. Thank you very much, Mr. Chairman.
Thank you. Representative Dubinsky.
Thank you, Mr. Chairman. Throughout this legislative session and the last couple of sessions, many of the bills put forward have had the intent of increasing the availability of housing to people of limited means, affordable housing, homeless housing, etc. And one of the questions that always comes to my mind is, why don't we have enough houses? And I've spoken with landlords who have told me that Connecticut's regulation and attitude towards landlords makes it very difficult for them to have housing units that people can afford. Obviously, anybody who ventures into that business needs to be able to maintain housing in good condition and in livable condition for the people who live there. So this bill is, I'm kind of on the edge whether or not this bill adds to the burdens that landlords have to create and maintain housing for the people of this state. For today, I'm gonna vote for it. But I think we need to be cognizant that housing doesn't just fall out of the sky. It happens when people invest their money to create it. And if we create an environment where they're not going to invest their money in Connecticut anymore, they're going to go invest it somewhere else. Well, somewhere else is going to get the housing. And I want to make sure that as we move forward with this bill and with any bill, we keep those people in mind and we do what we can not to scare them off, because they are the ones ultimately that will be putting their money up to house the people that either don't have adequate housing now or don't have housing that they can afford. Thank you, Mr. Chairman.
Thank you, Representative. The comment or question from members of the committee, comment or question from members of the committee? If not, Madam Administrator, please call roll.
Roll call vote on Senate Bill 209 to JF it to the floor. Winfield,
Winfield, in the affirmative.
Staffstrom,
Yes.
Flexer,
Yes.
Quinn,
Yes.
Kissel,
Yes.
Fishbein,
Yeah.
Blumenthal,
Yes.
Callahan,
Yes.
Conley, Curry, Delaney, Dillon,
Yes.
Doucette,
Doucette, yes. Delaney, yes.
Dubitsky,
Yes.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey,
Yes.
Paul,
No.
Harding, Hayes, Howard,
No.
Johnson,
Yes.
Khan,
Yes.
Labriola, Lesser, Mar,
Yes.
Miller,
Miller, yes.
O'Day,
O'Day, yes.
Lesser,
Lesser, yes.
Osborne,
Osborne, yes.
Havelock Tomato,
Havelock Tomato votes no.
Porter, Sampson, Sims,
Sims in the affirmative.
Veach,
No.
Walker, Wilson,
Thank you, Madam Administrator. Item number 3, Senate Bill number 272, an act concerning adoption of the Connecticut Uniform Trust Decanting Act. The JFS language is LCO 3531. Is there a motion? Moved by Senator Kissel, seconded by Representative Staffstrom. Is there discussion? The JFS language adds a new section and fixes the internal references based on the fact that there is a new section. It also has a section which is new that regards a filing fee for the decanting petition. Senator Kissel.
Thank you very much, Chairman Winfield. Just briefly, I know that members of the bar in a section that deals with trusts and estates came and proffered this request for a bill addressing this. Whenever we have proposed uniform laws, they're somewhat uniform in that they tend to vary a little bit state to state, but they use sort of the same template to begin with. And one of the things that this will do will allow Connecticut to be on the same playing field as other states that have adopted similar laws. And for the folks practicing in trusts and estates, when they have clients that have certain trusts, they want to be able to point to statutory guidelines that are being followed as they move forward with a procedure that's called decanting. And my understanding, and I don't practice in this area, is that these folks are involved in the careful crafting of documents that allow trusts to move from one document form to another similarly situated type of form, thus decanting like one would decant a bottle of wine from one area to another. This is the trust moving from trust provisions A to trust provisions B. It doesn't change the fundamental nature of what's being done. but it's a transference, and what this will do will allow folks that want to avail them of these legal services the reassurance that it is based and predicated on a statutory structure here in Connecticut, so that they don't look for legal representation in other states, such as the Commonwealth of Massachusetts or New York or New Jersey. And so with that, I'm happy to support this proposal. Thank you, Mr. Chair.
Thank you, Senator. Comment or question from other members of the committee? Comment or question from other members of the committee? If not, Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I move that we create a consent calendar and that we move item number 3, SB 272, an act concerning adoption of the Connecticut Uniform Trustee Canting Act to that consent calendar.
Moved by Representative Fishbein. Is there objection? Seeing none. This item will be placed on, Madam Administrator, please begin a consent calendar and place this item, number 3, Senate Bill number 272 JFS LCL 3531 on the consent calendar. Number 4, Senate Bill number 324 JFS language is LCL 3288. It is an act concerning the probate court operations and administration. Is there a motion?
So moved.
Moved by Senator Kissel, seconded by Representative Fishbein. Is there discussion? Yeah, Representative Stastrom. What did I say? Oh,
They're very easily mixed.
it's like you and I. Seconded by Representative Stastrom. Representative Fishbein.
Thank you, Mr. Chairman. There are some aspects of this bill that I don't feel comfortable voting for, most especially is the name change fee. A lot of people don't understand that our probate court system is fee driven. That, generally it's almost like an enterprise fund. The money that comes in is utilized to fund its operations, as opposed to our Superior Court where, you file a motion for continuance in the Superior Court, there is no fee. You file a motion for contempt in the Superior Court, there is no fee. But in the probate court, you file those motions, there are fees because they use that stuff. And I think it was last legislative session, or perhaps the one before, that we as the legislature removed the fee for a name change. And, name changes, they still have to have hearings, still got to do papers, all that stuff. There is a standard. There's actually a standard for an adult to change their name, which I learned in this last legislative session. So, I know that that's been a bone of contention up here. The probate court administration at least would like to restore that fee. That is not part of the legislation that's before us for whatever reason. And I do intend to oppose this bill generally for that concern. So thank you, Mr. Chairman.
Thank you very much, Representative Fishbein. Representative Dubinsky.
Thank you, Mr. Chairman. In section 5, there are terms that are replaced. Putative father is replaced with alleged genetic parent. And the word mother is replaced with birth parent. When I grew up, they told me that mothers are women because only women can give birth and because only women have wombs, and they are mothers. I don't understand the intent to replace mothers with birth parent. I think it does violence to the English language, and it and the same with changing father to alleged genetic parent. We have men and women who are mothers, who are fathers and mothers. And I think our statutes should reflect that. So I will not be supporting this today. Thank you.
Thank you, Representative. Comment or question from other members of the committee? Comment or question from other members of the committee? If not, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 324 to JFS it to the floor with LCO 3288. Winfield,
Winfield, in the affirmative.
Staffstrom,
Yes.
Flexer, Quinn,
Yes.
Kissel,
Yeah.
Fishbein, Blumenthal, Callahan,
No.
Conley, Curry, Delaney,
Delaney, yes.
Dillon,
Yes.
Doucette, Drubitsky,
No.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey,
Yeah.
Hall, Harding, Hayes, Howard,
No.
Johnson,
Yes.
Khan, Labriola, Lesser, Mar,
Mar, yes.
Miller,
Miller, yes.
O'Day,
O'Day, no.
Osborne, Pavlock D'Amato,
Osborne, yes.
Havelock D'Amato votes no.
Porter,
Osborne, yes.
thank you. Sampson, Sims,
In the affirmative.
Veach. No. Walker,
Yes.
Wilson,
Walker, yes.
Blumenthal,
Blumenthal, yes.
and Flexer. Thank you.
Thank you, Madam Administrator. Item number 5, Senate Bill number 350, an act concerning the use of body scanning machines in the public entrance of correctional facilities.
So moved.
Moved by Senator Kissel, seconded by Representative Staffstrom. Representative Fishbein.
Thank you, Mr. Chairman. I'm going to support this bill here today. You know, I very concerned over the last couple of years, the amount of contraband that has been found in our correctional facilities. You know, contraband from any source is a threat to not only our corrections officers, but those that are inmates. And, you know, I know this is a report. I know we were part of the discussions last session on the body scanning equipment. I know that there will be more talks about this, but I think that everybody should be safe when they are entering our correctional facilities as much as possible. So, thank you, Mr. Chairman.
Thank you, Representative. Comment or question from members of the committee? Comment or question from members of the committee? Senator Kissel.
Just real briefly, I'd just like to thank the chairs and leadership of this committee for moving this forward. I think with the whole idea of body scanners, we're entering into an era where we could utilize technology more and more. I know that there's some controversy regarding body searches in our correctional facilities. We're trying to look for ways to maybe minimize that, and that would be a positive movement for both the corrections inmates as well as the officers that are tasked with having to perform that. And often contraband is snuck into correctional facilities through visitation. And so the body scanners can be of benefit to both of those areas as far as reducing contraband getting into facilities, whether it's a weapon or some kind of drug. And also reducing the amount of violence that takes place in facilities which are a threat and danger and harms both the correctional inmates, the individuals housed within correctional facilities, and correctional officers. And so for that, I'm looking forward to this report and what we learn from it. Thank you, Mr. Chair.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? I'll just say this. I am supporting this bill today. I'm not sure I would support it in this form on the floor, but I think it relates to a larger conversation that's been happening in the General Assembly, both on people who are entering our prison, but also on people who are currently housed in our prison and the ability to at least see what's going on with them. There has been a conversation that Stop Solitary is engaged in that has not been finished or made enough progress, if you ask me. that this relates to. And so I think as we move forward, the potential for this bill to find itself to completion has something to do with the Department of Corrections and Stop Solitary having a conversation, or we can just bring back another bill next year again and have that conversation in that way. Madam Administrator, would you please call a roll?
Roll call vote on Senate Bill 350 to JF it to the floor. Winfield,
Winfield, any affirmative?
Statstrom, Flexer, Quinn,
Yes.
Kissel,
Yeah.
Fishbein, Blumenthal,
Yes.
Callahan,
Yes.
Conley, Curry, Delaney,
Delaney, yes.
Dillon,
Yes.
Doucette, Dubitsky,
Yes.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey, Hall, Harding, Hayes, Howard, Johnson,
Yes.
Khan, Labriola, Lesser,
Answer yes.
Mar,
Mar, yes.
Miller,
Miller, yes.
O'Day,
O'Day, yes.
Osborne,
Osborne, yes.
Havelock Tomato,
Havelock Tomato votes yes.
Porter, Sampson, Sims, Beach,
Yes.
Walker,
Walker, yes.
Wilson,
Thank you, Madam Administrator. All right, jump with me to item number 17. An act concerning legal protections for victims of sexual assault. The JFS is LCO 3529. Is there a motion?
So moved.
Moved by
Second.
Representative Gilchrist, seconded by Senator Kissel. Representative Gilchrist?
Thank you, Mr. Chair. This bill is meant to ensure that we make all victims of gender-based violence a protected class. A few years back, we started with victims of domestic violence. And so what you have before you would add victims of sexual assault, human trafficking, and stalking to our statute. And I would ask for support. Thank you.
Thank you, Representative. Comment or question for members of the committee? Comment or question for members of the committee? Representative Fishbein.
Thank you, Mr. Chairman. I must admit, when you said jump with me to number 17, I was thinking of Willy Wonka, but that was the picture that I had, and can't get that out of my mind at this moment. But anyway, you know, I do recognize that a few years ago we did extend protected classes to domestic violence, to victims of domestic violence, and certainly, you know, I've represented people on both sides of these cases, and domestic violence is a scourge that I don't think we can ever get rid of. We try, but you know, that's just the reality. When we extend protections, you know, these protections started out at a level that was very limited, mirroring the feds, actually. Connecticut adopted the federal standard, then started to expand. What we have here is another expansion. And you have to ask at some point, when does it potentially end? You know, we've had it over the last year. We had Chief Justice Robinson came to us and said, well, judges, they should be a protected class. And we said, no. We've had athletic officials come to us and, you know, we should be a protected class. And we said, no. As we see the increase in property crimes across our state, I have to say, you know, there are victims of those crimes as well. Part of this legislation has to do with taking time off from work because you have to attend to your affairs as a result of you being a victim of human trafficking, for instance. Well, there's other people that have to take time off from work because they are a victim of crime as well. Victims of hate crimes. Should they be a protected class? Just like these other individuals. We have a statute 53A 181J, which is intimidation based upon bigotry or bias in the first degree. In my mind, it's a very serious situation. It's a Class C felony. Of course, under the clean slate statutes, a few years ago, we decided for public policy that those that have violated this crime in particular, their convictions are erased, but there are still victims. In order to be found guilty of this, one has to maliciously and with specific intent to intimidate or harass another person motivated in whole or in substantial part by actual or perceived race, religion, ethnicity, disability, sex, sexual orientation, or gender expression, identity or expression, cause physical injury to such other person or to a third person. It's very akin to what we're dealing with here today in various bills. So why shouldn't a victim of a hate crime as heinous as this also be considered a protected class? If we're going to go down this road, then let's do it. Of course, at some point you end up with everybody's a protected class and the minority becomes those that aren't. I think as originally intended, the protected class was to be the minority. And with that, Mr. Chairman, I make a motion that we add to HB 515414, a victim of 53A 181J, intimidation based on bigotry or bias in the first degree. And I ask that should the motion pass, the conforming changes be made to the bill in accordance. So moved.
Is there a second?
Second.
Second, moved by Representative Fishbach, seconded by Representative Howard. Is there discussion? Representative Gilchrist.
Thank you, Mr. Chair. As I mentioned at the start, we are trying to align, we're trying to ensure that our current law reflects those victims of gender-based violence as a protected class, which would bring us in line with 8 states who have already done so. And so for that reason, I would ask that my colleagues oppose the amendment. Thank you.
Thank you, Representative Gilchrist. Further discussion on the amendment? Further discussion on the amendment? Seeing none, Madam Administrator, please call the roll.
Roll call vote on Amendment A for House Bill 5414. Winfield,
Winfield in the negative.
Staffstrom.
No.
Flexer.
No.
Quinn,
No.
Kissel,
Yes.
Fishbein.
Yes.
Blumenthal.
No.
Callahan,
Yes.
Conley, Curry, Delaney,
Delaney, no.
Dillon, Doucette.
Sorry, no, Dylan, no.
Thank you, Doucette. Dubitsky,
Yes.
Elliott, Gaston,
No.
Gilchrist, Godfrey, Hall, Harding, Hayes, Howard,
Yes.
Johnson,
No.
Khan,
No. Conlon.
Labriola, Lesser,
No.
Mar,
No.
Miller,
No.
O'Day,
Yes.
Osborne, Pavlik Tomato, Porter, Sampson,
Osborne, no.
Sims, Beach,
Yes.
Walker.
Representative Curry's a no.
Thank you. Wilson?
When you're ready, Madam Administrator.
The final tally for the amendment is 7 voting yay, 20 voting nay, and 10 absent.
Thank you, Madam Administrator. The motion fails. Representative Fishbine?
Thank you, Mr. Chairman. Well, that's unfortunate because I certainly do support victims of hate crime in our state. Another similar crime that one could be a victim of that doesn't fall within the protections of these new protected classes is victims of prostitution. One who's convicted of promoting prostitution, more than likely there is a victim. There is the person who is, through human trafficking or for whatever reason, perhaps that's not proven, is the victim of promoting prostitution in the first degree, which is 53A86. And in order to be convicted of that, a person is guilty of promoting prostitution in the first degree when he, so I guess only men, this can only be charged against men, advances prostitution by compelling a person by force or intimidation to engage in prostitution, or profits from coercive conduct by another, or advances or profits from prostitution of a person less than 18 years old. So there has to be another person involved in this who is coerced, intimidated in order to engage in prostitution. I think that as the public policy that we're advancing today, that those individuals also should be a protected class. And therefore, Mr. Chairman, I make a motion that we add to 5414 a victim of 53A86 promoting prostitution in the first degree, which is the Class B felony. And I ask that should the motion be passed, the LCO make conforming changes throughout. Thank you.
Thank you, Representative. Is second to the motion?
I'll second.
Thank you, Representative Howard. Motion is made by Representative Fishbine and seconded by Representative Howard. Is there further discussion? Representative Gilchrist.
Thank you, Mr. Chair. I would let the good proponent of this amendment know that if someone is the unwilling participant in prostitution, then they are a victim of trafficking and would be eligible under the proposal before us. And for those reasons and the reasons I stated earlier, I would ask that my colleagues oppose the amendment, which is unnecessary.
Thank you, Representative Gilchrist. For the conversation, Representative Fishbine.
I just want to point out that there's no reference to 5386 in the legislation that's before us. So that's it. Thank you, Mr. Chairman.
Thank you. Thank you, Representative Fishbine. I'd still ask folks to vote against the amendment. Madam Administrator, please call the roll.
Roll call vote on Amendment B. Winfield,
Winfield in the negative.
Staffstrom, Flexer, Quinn, Kissel, Fishbine, Blumenthal, Callahan,
Yes.
Conley, Curry,
No.
Delaney,
No.
Dillon,
No.
Doucette, Dubitsky,
Yes.
Elliott, Gaston,
No.
Gilchrist, Godfrey, Paul, Harding, Hayes, Howard, Johnson,
No.
Khan,
No.
Labriola, Lesser,
Yes or no?
Mar,
Or no.
Miller,
Miller, no.
O'Day,
O'Day, yes.
Osborne,
Osborne, no.
Pavlock D'Amato, Porter, Sampson, Sims, Beach,
Beach is a yes.
Walker, Wilson.
Whenever you're ready, madam.
Final tally is 7 voting yea, 20 voting nay, and 10 absent.
Thank you. The amendment fails. Representative Fishbone.
Thank you, Mr. Chairman. I certainly feel for victims of prostitution, but another one that I ran across that's somewhat in line with what the public policy that underlies this bill is, I think we have something with regard to this today. Another bill is unlawful dissemination of intimate image. Very similar to some of the stuff that we've talked about during this session to protect victims, and in order to be found guilty of violating that, person is guilty of unlawful dissemination of an intimate image when such person intentionally disseminates by electronic or other means a photograph, film, or videotape or other recorded images of the genitals, the pubic area, or the buttocks of another person with less than a fully opaque covering of such body part, or the breast of such other person who is a female, with less than a fully opaque covering of any portion of such breast below the top of the nipple. There are other ways that one could be found to be in violation of this, but one of the things that we heard about, I think it was a couple years ago, was the upskirting, where, you know, somebody took a video of young lady going up the elevator and then it disseminated that to others. Certainly, I would want that individual who was offended by that, and I'm offended by that activity, to be able to go to court, meet with the prosecutor, meet with the victim's advocate, be part of the system, and not be discriminated against in their employment because they took time off from work. So I think that's right in line with what we're talking about here today. And with that, Mr. Chairman, I make a motion that we add to the protections of 5414 a victim of 53A 189C, unlawful dissemination of an intimate image. So moved.
Thank you, Representative Fishbone, seconded by Representative Howard. Representative Gilchrist.
Thank you, Mr. Chair. I would just say again, the proposal before you has been worked through with advocates and professionals who are trying to align with the 8 other states who protect victims of gender-based violence. And so I would ask my colleagues not to support the amendment. Thank you, Mr. Chair.
Thank you. Comment or question from other members of the committee? Comment or question from other members of the committee? If not, Madam Administrator, please call the roll.
Roll call vote on Amendment C. Winfield,
Winfield in the negative.
Staffstrom, Flexer, Quinn, Kissel, Fishbein, Blumenthal, Callahan,
Yes.
Conley, Curry,
No.
Delaney,
No.
Dillon, Doucette,
No.
Dubitsky,
Yes.
Elliott, Gaston,
No.
Gilchrist, Godfrey, Hall, Harding, Hayes, Howard, Johnson,
No.
Khan,
No.
Labriola, Lesser,
Lesser no.
Mar,
Mar, no.
Miller,
Miller, no.
O'Day,
O'Day, yes.
Osborne,
Osborne, no.
Havelock D'Amato, Porter,
Porter votes in the negative.
Sampson, Sims, Beach,
Yes.
Walker,
Walker, no.
Wilson,
When you are ready, madam.
Madam Clerk, Dylan was a no, and I don't know if that was recorded.
I have you as a no.
Thank you.
Final tally is 7 voting yay, 22 voting nay, and 8 absent.
Thank you, Madam Administrator. The amendment fails. Further. Representative Fishpaw, no, yes. Go ahead, yes, Representative Fishpaw.
You know, perhaps we can get this thing to a much better place, but at this point, I'm gonna have to vote no, so thank you.
Thank you, Representative Fishpaw. Comment or question from other members of the committee? Comment or question from other members? Seeing none, Madam Administrator, please call roll.
Roll call vote on House Bill 5414 to JFS it to the floor with LCO 3529. Winfield,
Winfield in the affirmative.
Staffstrom, Flexer, Quinn, Kissel, Fishbein, Blumenthal,
Yes.
Callahan,
No.
Conley, Curry, Delaney,
Delaney, yes.
Dillon,
Yes.
Doucette, Dubitsky,
No.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey, Paul, Harding, Hayes, Howard, Johnson,
Yes.
Khan,
Yes.
Labriola, Lesser,
Lesser, yes.
Mar,
Mar, yes.
Miller,
All right.
O'Day,
Miller, yes.
O'Day,
O'Day, no.
Osborne,
Osborne, yes.
Havelock D'Amato, Porter,
Porter votes in the affirmative.
Sampson, Sims, Beach,
No.
Walker,
Walker, yes.
Wilson,
Okay. Okay, we're going to move now to item number 19, House Bill number 5421, an act concerning unlawful dissemination of intimate images that are digitally altered or created through the use of artificial intelligence. Is there a motion?
So moved. Second.
Moved by Senator Kissel, seconded by Representative Staffstrom. Is there discussion? Representative Fishbein.
I I frequently say, don't tell me I can't do something, especially at home. So I didn't even think this was possible until the Taylor Swift started. And I was told not to bring up Taylor today. So I've been in support of this bill throughout, because I'm protecting Taylor. So I am going to vote in support, and thank you, Mr. Chairman.
Thank you, Representative Fishbein. Is there further comment or question from members of the committee? Further comment or question, Representative Staffstrom?
Mr. Chair, I make a motion that we add HB number 5421 to the consent calendar.
Motion by Representative Fishbein. Is there, I'm sorry, I was expecting Fishbein, sorry. Representative Staffstrom, is there, discussion? Opposition, rather. Is there opposition? Is there opposition? Seeing none, this item will be ordered onto the consent calendar. All right, number 20, House Bill number 5466. There is a JFS. It is LCO 3540. Is there a motion?
So moved.
Moved by Representative Staffstrom, seconded by Representative Fishbein. Is there discussion? Representative Fishbein.
Thank you, Mr.
I mean,
Chairman.
Staffstrom's gonna go first,
got
sorry.
it.
All right. Thank you, Mr. Chair. Mr. Chair, this bill is pretty straightforward. The JFS on this, just for the record, is LCO 3540. What this does is extend the statute of limitations for bringing election-related crimes. As we've seen from time to time, sometimes there's an investigation by SEEK. Those investigations can tend to drag, given the amount of documents and witnesses that need to be interviewed. And if they turn up what they believe may have been criminal conduct, by the time they turn that over to the state's attorney's office, it is too late to prosecute for those crimes, because of the statute of limitations for election crimes. So what this would do is provide a window of 6 months for the state's attorney to bring charges.
Thank you. Representative Fishbein?
Thank you, Mr. Chairman. Mr. Chairman, I move that we move item number 20, which is HB 5466, an act concerning the period of time during which elections-related crimes may be prosecuted, to the consent calendar.
Thank you, Representative Fishbein. There, second.
Second.
Is there objection to placing this item on consent? Is there objection to placing this item on consent? Seeing none, item number 20, HB number 5466, LCO 3540 would be placed on the consent calendar.
Just keep going.
Number 21, House Bill number 5467, an act concerning firearms background checks. Is there a motion? Moved by Representative Staffstrom, seconded by Representative Fishbein. Representative Staffstrom.
Thank you, Mr. Chair. Mr. Chair, that might be the very first time ever in this committee that there was a bill that included the title of the word firearms, that you said Staffstrom moved it, and it was seconded by Fishbein. So just let the record reflect that cats and dogs can play together. And I think that's because, Mr. Chair, this is a fairly simple technical fix bill that simply allows, under the Bipartisan Safer Communities Act, for the state of Connecticut to share certain juvenile data with the national database, so that someone who's prohibited from purchasing a firearm in Connecticut would be prohibited in other states as well under the enhanced background checks.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? If not, Madam Administrator, please call a roll.
Roll call vote on House Bill 5467. JF to the floor. Winfield,
Winfield, affirmative.
Staffstrom.
Yes.
Flexer.
Yes.
Quinn,
Yes.
Kissel. Fishbein. Blumenthal.
Yes.
Callahan,
Yes.
Conley, Curry,
Yes.
Delaney,
Yes.
Dillon,
yes,
Doucette,
Doucette, yes.
Kubitsky,
No.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey, Paul, Harding, Hayes, Howard, Johnson,
Yes.
Khan, Labriola, Lesser,
Yes.
Mar,
Mar, yes.
Miller,
Miller, yes.
O'Day,
O'Day, yes.
Osborne,
Osborne, yes.
Havelock Tomato,
Havelock Tomato votes yes.
Porter, Sampson, Sims, Beach,
Beach is a yes.
Walker, Wilson.
Wilson votes yes.
Walker votes in the affirmative.
Thank you.
Lesser in the affirmative.
Thank you. Item number 22, House Bill number 5487, an act concerning the operation and administration of the Office of the Claims Commissioner. To be clear, it is a JFS. It's LCO 3422, moved by Representative Stashel, seconded by Senator Kissel. Representative Staffstrom.
Thank you, Mr. Chair. Mr. Chair, this bill contains various and sundry changes that have come to us from the Office of the Claims Commissioner, as well as the work of this committee in dealing with administration of claims. The JFS language simply makes some technical changes to Section 4 to address a concern that was raised by the Office of the Attorney General.
Thank you, Representative. Comment or question from members of the committee? Comment or question from members of the committee? Representative Fishbone.
Thank you, Mr. Chairman. Mr. Chairman, I move that we move item number 22, HB 5487, an act concerning the operation and administration of the Office of the Claims Commissioner to the consent calendar.
The item has been moved to the consent calendar. Is there objection? Is there objection? Seeing none, LCO, item number 22, House Bill number 5487, LCO 3422 will be moved to the consent calendar. Number 23, House Bill number 5500, an act concerning. It is LCO 3451. Just for clarification, it was moved by Senator Kissel and I believe seconded by Representative Staffstrom. Is there discussion? Representative Staffstrom.
Thank you, Mr. Chair. Mr. Chair, this is our annual criminal justice aircraft carrier. It contains several sections directed at various pieces of our criminal justice system that have been signed off on by both the public defender and the chief state's attorney, as well as some provisions that have come to us from the good work of the Connecticut Sentencing Commission, and a few other provisions, including those related to juror compensation from the judicial branch.
Thank you, Representative. Comment or question from members of the committee? Comment or question from member of the committee? Representative Fishbone.
Thank you, Mr. Chairman. Mr. Chairman, I move that we move item number 23, HB 5500, an act concerning the revision to various laws concerning jury compensation, Department of Correction, and criminal law and criminal procedure to the consent calendar.
Thank you, Representative Fishbone. Has been moved to the consent calendar. Is there objection? Is there objection? If not, number 23, HB 5500, LCO 3451 will be moved to the consent calendar. Number 24, House Bill number 5505, an act concerning self-defense, defense of a third person, and assisting or in or effecting an arrest as affirmative defenses.
So moved.
Moved by Senator Kissel, seconded by Representative Fishbone. It is a JF. Is there discussion? Representative Staffstrom.
Briefly, Mr. Chair, this bill simply creates a process to allow for a more expedited dismissal of charges where someone can show they have the available self-defense.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? Representative Fishbone.
Yes, thank you, Mr. Chairman. Mr. Chairman, I move that we move item number 24, HB 5505, an act concerning self-defense, defense of the third person, assisting in or effecting an arrest as affirmative defenses to the consent calendar.
Thank you, Representative Fishbone. Has been moved to the consent calendar. Is there objection? Is there objection? Seeing none, Number 24, House Bill number 5505, will be moved to the consent calendar. Okay, we will jump back to number 7, which is Senate Bill number 360, an act concerning transcript fees charged by official court reporters and court reporting monitors, JFS LCO 3289. Is there a motion?
So moved.
Second.
Moved by Senator Kissel and Representative Staffstrom. Is there discussion on the item? Is there Representative Staffstrom?
Just briefly, Mr. Chair, this is LCO 3289 is the JFS language. The JFS language retains section 1, which has the per page fee increase, but it deletes section 2 from the underlying bill.
Thank you, Representative Stafford. Representative O'Day.
Thank you, Mr. Chair. Just briefly, I'm going to vote yes for this, but I've had conversations with my fellow trial lawyers on in this committee on the issue where, we used to be able to get transcripts overnight, so that you have a trial, you ask a court reporter to do an overnight transcript, you get it the next day, so you can utilize it in court. That's no longer possible, at least hasn't been in my last few trials. And on one occasion, we were told we couldn't get overnight transcripts. So we hired our own court reporter to come in and give us overnight transcripts. And then ultimately the judge said we could do that. And the union objected. And so we ultimately couldn't use those transcripts as accurate court transcripts for the trial. So this is a problem that needs to be addressed. Obviously, it's not going to be addressed in this bill, but we're increasing the pay. I don't disagree that there is a need for increased pay, but we should be able to get overnight transcripts. And if we can't, we should be able to use our own court reporter. So I just want to highlight that, and hopefully maybe we can address that. If not this session, next session. Should I be reelected? Thank you.
Thank you, Representative. Comment or question from members of the committee, Representative Fishbach.
Thank you, Mr. Chairman. I am sensitive to the points that the good representative brings to our attention. I will caution, though, that just because you get a quick transcript does not mean that you get remedy. And I learned that years ago when a quick transcript did not accurately reflect what a judge said during the proceeding. And the judge had said, you call the life insurance company. And it reflected that I was directed to call the life insurance company. But they're talking about the life insurance of the other litigant who was represented by counsel. So then the lawyer got fired, and the pro se party filed a grievance against me and said, well, the judge ordered me to call his life insurance company. And ultimately, I had to file all these motions to get the transcript corrected. Grievance was vacated because the record accurately reflected what happened in court. But that was over getting a very quick transcript. So I don't know that, I think something needs to be done there. Certainly getting a quick transcript can be of benefit, but a rushed transcript that's not accurate can be very harmful. So I am in support of the bill, and I thank you, Mr. Chairman.
Thank you, Representative Fishbein. Are there other comments or questions? Other comments or questions? Representative Fishbein?
Yes, thank you, Mr. Chairman. Mr. Chairman, I make a motion that we move on item number 7, SB 360, an act concerning the transcript fees charged by official court reporters and court reporting monitors to the consent calendar.
Thank you, Representative Fishbein. It's been moved to the consent calendar. Is there objection? Is there objection? Seeing none, item number 7, SB number 360, JFS LCO 3289 will be moved to the consent calendar. Item number 8, an act prohibiting discrimination by healthcare providers in the provision of healthcare services in the state. The LCO on this is 3554. Is there discussion? Oh, that's right. Moved by Representative Staffstrom, seconded by Senator Flexer. Is there discussion? Representative Howard.
Thank you, Mr. Chairman. Conceptually, I agree with this wholeheartedly. I I appreciate the addition in section 1 under the new S language. Nothing in this section shall be construed to require delivery of fetal health care, affect the professional standard of care, or interfere with public health planning. It makes me feel a little better about it. I still have a little, conceptually, again, I agree. I have a little bit of concern that we are putting too much legislative control over healthcare services. I think I'd feel a lot better if in line 3, we added the word emergency to provide emergency healthcare services. And I'd like to propose that actually as a verbal amendment. In line 3, between the words provide and health, insert the word emergency.
Moved by Representative Howard, seconded by Senator Kissel. Discussion. Representative Stafford.
Thank you, Mr. Chair. Mr. Chair, at this point, I'm going to ask my colleagues to oppose the amendment. I don't know that it's necessary, and frankly, I think it could undercut some of the intent of the underlying bill, which, and frankly, in a significant way. I mean, I think the intent of the underlying bill is someone can't and shouldn't be allowed to deny services to someone just because of their race or their gender. And so, you know, if somebody is African American and walks into a hospital for emergency services, or if they walk into, frankly, a primary care physician for elective services, they should be treated the same. And I think to make this limited just to emergency services is a bridge too far, at least in my book. So I'm going to ask my colleagues to vote no.
Thank you, Representative Howard.
Thank you, Mr. Chair. I don't substantively actually disagree with the House Chair. Line 4 says age. So am I to understand then if this bill passes and a 65-year-old walks into a pediatrician's office and wants to be seen, that it'd be discriminatory to not allow them to based on their age?
Representative Stafford.
No, not in the least bit, Mr. Chair. What this, right now, we have plenty of different organizations and plenty of different places where someone's age matters, right? Last night I went to my coach's meeting for Black Rock Little League. Anybody out there listening wants to play Black Rock Little League, still have a couple spots on my team. We're gonna be pretty good this year. Got a lot of returning second graders, but you know, you got to be in second grade to play on my Little League team, or first grade. You know, if as much as I'm sure Representative Howard would love to come play Little League for me, he's not allowed to do that. That's not discrimination. That's just one of the requirements. So if you're a pediatrician and the requirement is you only take kids under the age of 18, that's the requirement, and that has never been considered age discrimination, nor would it be under this bill. 3.
Thank you, Representative Stafford. I just think it's important to say this as well. Black folks have been denied treatment based on what has been taught in some of our medical schools, and until very recently was still being taught in some of our medical schools about the amount of pain that Black folks could endure, and the density of their skin, and women who were in labor did not often get the treatment they should get, and those aren't emergency services. So this is particularly important the way that it is. And in terms of age, what we're really talking about there are things like a treatment not being given to someone because of their age, not in a pediatric sense, but just not being given to someone because of their age, not because they have a fitness issue or a health issue, but because of their age alone. And so I think it's very important that we move forward with this bill in the way that it's constructed. And I would add my voice to the desire not to vote for the amendment, though I understand why it's before us. Comment or question from other members of the committee? Comment or question from other members of the committee? Seeing none, Madam Administrator, please call. Oh, wait, I'm sorry. Hold on. Representative Pavlik D'Amato.
Is this on the amendment right now? Because I'd rather
Yes,
speak on
we
the
are.
bill.
Okay. Madam Administrator, please call the roll.
Roll call vote on Amendment A. Winfield,
Winfield in the negative.
Staffstrom,
Legal this.
Flexer, Quinn, Kissel, Fishbein, Blumenthal, Callahan,
Yes.
Conley, Curry,
Curry's a no.
Delaney,
Delaney, no.
Dillon,
No.
Doucette,
Set, no.
Dubitsky,
Yes.
Elliott,
Elliot, no.
Gaston,
No.
Gilchrist, Godfrey, Hall, Harding, Hayes, Howard, Johnson,
No.
Khan,
No.
Labriola, Lesser,
Lesser no.
Mar,
Mar, no.
Miller,
Miller, no.
O'Day,
Yes.
Osborne,
Osborne, no.
Pavlik D'Amato,
Pavlik D'Amato votes yes.
Porter,
Porter votes in the negative.
Sampson, Sims,
Sims, no.
Veach,
Yes.
Walker,
Walker, no.
Wilson,
Wilson, no.
Thank you very much. Further comment, question on the amendment, on the bill. I'm gonna go to Representative Pavlik D'Amato first.
Thank you, Mr. Chair. I did have a question. The bill on line 4 does refer to discrimination based on gender identity or expression. And so in the event where somebody goes to a gynecologist and the gynecologist says, I only work on women, and refuses to see a man who comes in, would then that doctor be subject to a lawsuit under this bill?
Representative, could you repeat the question so that the individual who respond can hear your question? I'm sorry.
Sure. On line 4, the bill refers to gender identity or expression. And so in the event that an individual goes to a gynecologist, let's say a man goes to a gynecologist and wants services, and the gynecologist states that they only work on women. So in that case, would they be subject to a lawsuit, or would they commit discrimination under this bill through you?
Senator Flexer.
Thank you, Mr. Chair. Through you, Mr. Chair, to the good representative, similar to the response that Representative Staffstrom gave with regard to age, I believe that any provider would be able to place appropriate limits in terms of the delivery of health care with regard to gender identity or expression as well. And so in the scenario that the good representative described, a provider would be able to determine whether that person could receive the appropriate healthcare services from that particular practice.
Thank you, Representative. Representative Pavlik D'Amato.
Okay, so my concern is for a doctor who, let's say, does not have, let's say if a trans individual went to the doctor and the doctor, did not have the training, did not have the skills, that would require treatment for this individual, that ultimately a lawsuit could be brought against them simply because they don't, they can't provide adequate care to that patient. And so, my concern is it doesn't really make those carve outs, I feel, that that the good representative is stating. And I believe CHRO, often places individuals in these situations just to see if there's a response. I'm not saying with a doctor, but in other scenarios, I know that to be true. And so, like, what path are we going down here? You want somebody to provide adequate care. And sometimes that involves telling the person, I can't provide you adequate care here. I need you to go to somebody else. I know I do it as an attorney if I don't feel I have the skills. And so now, what path are we going down? Next, I can't provide for a client and for the better of their situation. And here, for the better of their health, you're asking them to go somewhere else, somebody who can provide better care. You know, doctors take an oath, and sometimes that means referring them to somebody else. That's why we have specialists. So again, I will be voting against this bill, and I do encourage my colleagues to do the same. Thank you.
Representative Fishbach.
Thank you, Mr. Chairman. Mr. Chairman, a question for the proponent, if I may.
You may proceed.
What is the definition of healthcare provider as contemplated in line 2? Because I see no reference back to any statute through you.
Just a moment, Representative Fishbach. Representative Stastra.
Thank you, Mr. Chair. I direct the ranking member to line 8. Healthcare provider means any person, corporation, facility, or institution licensed in this state to provide healthcare services, or an officer, employee, or agent thereof, acting in the course and scope of such person's employment.
Thank you, Representative Stastra.
So I'm just trying, I mean, it's sort of like the definition is in the answer. So I guess it begs the question, is a mental health care provider, are they falling under this language through you?
Representative Stastra.
Through you, if they're providing healthcare services, then yes.
Representative Fishbach.
Okay, so I don't know if any of you have tried to get a mental health professional these days. Since the pandemic, it is extremely difficult, especially for children. You know, I was talking to a medical provider the other day, and he's moving to Wisconsin because we got all these rules coming from Hartford boxing these people in. I have no problem with the scenario that the good chairman gave us initially, with, you know, looking to prevent that kind of discrimination. But when you look at all of these things in here, so first of all, discrimination is gray. I get calls almost every day. I was discriminated against. But, you know, treating two people disparately is not necessarily discrimination. The general thought process out there as to what discrimination is a little flawed. But if we look at this list of things that is extensive: race, color, religious creed, sex, gender identity or expression, marital status, age, national origin, their ancestry, their intellectual disability, their mental disability, a learning disability, a physical disability, including but not limited to blindness, status as a veteran, or status as a victim of domestic violence. It's a very large list. Of course, it doesn't go as far as the protected classes that we dealt with in 5414. Perhaps that's language that we'll see in the future. But at this point, I cannot support this legislation. Once again, you are making it more difficult to do business in this state. So thank you, Mr. Chairman.
Thank you, Representative. Representative Stastra.
Thank you, Mr. Chair. Mr. Chair, I just want to clarify, based on the comments made by the last two representatives. This bill does not seek to force any provider to perform services they are not capable of providing or don't provide. All it is saying is, by use of the word discrimination, that it is a service that you otherwise provide. You hold yourself out to the public as doing, whether that is as a pediatrician, as a gynecologist, as a cardiologist, it doesn't matter. But that you treat someone different in the provision of the services you otherwise provide than someone else because of their status as a member of a protected class. That's what the bill does. I think we are looking to, or some may be reading far too deep into this and torturing some of the language before us. And so I just wanted to make that clear for intent of what's trying to be accomplished here.
Thank you, Representative Stastrom. Comment or question from other members of the committee? Comment or question from other members of the committee? If not, when you are ready, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 425 to JFS it to the floor with LCO 3554. Winfield,
Winfield in the affirmative.
Stafstrom, Flexer.
Yes.
Quinn,
Yes.
Kissel.
No.
Fishbein, Blumenthal,
Blumenthal votes yes.
Callahan,
Callahan, no.
Conley, Hurry, Delaney,
Delaney, yes.
Dillon,
Yes.
Doucette,
Doucette, yes.
Dubitsky,
No.
Elliott,
Elliott, yes.
Gaston,
Yes.
Gilchrist, Godfrey, Paul, Harding,
Harding, no.
Hayes, Howard, Johnson,
Johnson is yes.
Khan,
Khan is yes.
Labriola, Lesser,
Yes.
Marr,
Mars, yes.
Miller,
Miller is yes.
O'Day,
O'Day, no.
Osborne,
Osborne is yes.
Havelock D'Amato,
Havelock D'Amato votes no.
Porter,
Porter votes in the affirmative.
Sampson, Sims,
Sims in the affirmative.
Veach. No. Walker,
Walker votes in the affirmative.
Wilson,
Wilson votes yes.
Thank you, Madam Administrator. Item number 9, Senate Bill number 426, an act concerning court operations, JFS LCO 3541. Is there a motion?
So moved.
Moved by Senator Kitzel, seconded by Representative Stastrom. Is there discussion, Representative Stastrom?
Thank you, Mr. Chair. Mr. Chair, this is our annual court operations bill. Many, if not, I would say actually most of the changes come to us from recommendations from the judicial branch based on issues they've seen and ways to improve our court process, including clarifying some of the duties of the chief court administrator, certain court processes and procedures, and other duties and actions taken by attorneys and entities operating under the auspices of the judicial branch. The bill also contains some other provisions that have come to this committee's attention involving court procedure and ways to streamline and improve our process. With that, Mr. Chair, the committee should be in possession of an amendment. This is LCO number 3550. I would move the amendment.
It's been moved by Representative Stastrom, seconded by Representative Fishbein. Is there discussion on the amendment? Representative Stastrom.
Thank you, Mr. Chair. Mr. Chair, the amendment just fixes some language with respect to section 37 of the bill, which was requested by the judicial branch this morning.
Thank you, Representative Stastrom. Is there further conversation on the amendment? I see Representative Havelock D'Amato, is your question on the amendment? No. Is there further conversation on the amendment? If not, all in favor?
Aye.
Opposed? The ayes have it. Further on the bill as amended. Further on the bill as amended, Representative Havelock D'Amato.
Thank you, Mr. Chair. I just have a question for the either for the chair or any other individual about this bill. The later part of the bill adds a mediation process for foreclosure of a judgment lien. And I was wondering if you could just provide the reason behind that.
Representative Sastre.
Thank you, Mr. Chair. Mr. Chair, this provision comes directly out of a case that received some statewide media attention arising from Bridgeport a few months ago, where a woman was foreclosed out of her home and ultimately evicted over what amounted to an $8,000 credit card debt. And she lost her home over that debt. It certainly seemed to me, from having looked at that case, that this poor woman was not familiar with the court process, and that had she had available to her the foreclosure mediation program, which we apply in situations of foreclosure of a mortgage, but don't extend to foreclosures of consumer debt, that she might have been able to get into a payment plan, pay down her credit card debt, and keep her home, which turns out had significant equity in it. And so that's why we're extending the foreclosure mediation program to those types of consumer cases. We don't believe it is many, certainly compared to the number of foreclosure cases, but would provide some relief to certain individuals navigating the process.
Thank you, Representative. Further on the bill, Representative Dubitsky. Oh, I'm sorry. You're not sorry.
Thank you.
may continue.
So I guess my issue with this bill is that first, with a credit card, somebody gets a lawsuit, has notice, goes to court. And so in addition, when they are served the judgment lien, they also have the opportunity to litigate, to mediate. That opportunity is pretty much always there and always encouraged. But now we're adding mediation, right, which usually is in the facts of, let's say, a mortgage. A credit card can't redo the calculation of a mortgage, and there is no modification there. So this is giving somebody a third bite at the apple, and I see it every day because these are the types of lawsuits that I defend. But people have noticed over and over again, and the state has now required so much notice, I'll say, in the papers that are served on somebody, that people don't read them anymore. So I think that's something we need to consider going forward. But also that, you can provide somebody with a big flashing red stop sign, and sometimes they just think that ignoring it is going to make it go away. And unfortunately it doesn't, but they're given notice and opportunity and fair due process. So again, this is not really going to necessarily help anybody, because again, they could still ignore the mediation process and just ignore that, as they do, many individuals do now. So I will be voting no on this bill. Thank you.
Thank you, Representative. Representative Dubitsky.
Thank you, Mr. Chairman. I wanted to make a comment about Section 29, which frankly doesn't seem to have much to do with court administration or operations. This is something from the Department of Agriculture that significantly changes the way dog attacks are handled under our law. For many years now, probably almost 10 years, I have been trying to change the way that the administration of dog attacks and the handling of them by the ACOs, the Department of Agriculture, the appeal process, the court system. It is a very long and arduous system, and very frustrating for both the victim of dog attacks and the dog owners, given the length of time that it takes and the cost of having these claims and these crimes adjudicated. Couple years ago, we had a bill that created a task force to try to put together the stakeholders. There was a lot of discussion and negotiations about who should be on the task force. And we finally put together a group, and we finally got a bill passed, actually, that, that put this group together. But it never got, we got it passed, I believe, in the House, and it never got a vote in the Senate. We put together the group anyway with the Department of Ag and other stakeholders. But when there was a intervening election and we got a new governor, the group kind of broke apart. So I'm actually happy to see this bill. I'm not sure that it completely fixes the very significant problems in this area of the law, but at least it's a start, and at least it will give us something to work with going forward. Now that it is clear that the Department of Ag is finally taking this seriously, as hopefully the both chambers and the governor will as well. I'm not sure this is the perfect solution to this very extensive problem, but I do believe that it's a start, and I will be supporting it. Thank you.
Thank you, Representative Fishbein.
Yeah, thank you, Mr. Chair. I just want to thank the Attorney General's office and DOAG for meeting with me over the last week or so to work on Section 29, as well as 28, to try and get it to a place that I think is more congruent with our current system, works in line, and there's certainly the due process concerns that I had raised initially are certainly massaged to this. So I just wanted to shout out to them for their cooperation. Thank you.
Thank you, Representative. Further on the bill, if not, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 426 to JFS it to the floor with LCO 3541 and Amendment A with LCO 3550. Winfield,
Winfield, in affirmative.
Staffstrom,
Yes.
Flexer,
Yes.
Quinn,
Yes.
Kissel,
Yes.
Fishbein,
Yes.
Blumenthal, Callahan,
Callahan, yes.
Conley, Hurry, Delaney, Dillon,
yes,
Doucette, Dubitsky,
Yes.
Elliott,
Elliot, yes.
Gaston,
Yes.
Gilchrist, Godfrey, Paul, Harding,
Harding, yes.
Hayes, Howard, Johnson,
Rep. Johnson is yes.
Khan,
Khan is yes.
Labriola, Lesser,
Yes.
Mar,
Mars, yes.
Miller,
Miller is yes.
O'Day,
O'Day, yes.
Osborne,
Osborne is yes.
Havelock D'Amato,
Havelock D'Amato votes no.
Porter,
Porter votes in the affirmative.
Sampson,
Sampson is no.
Sims,
Sims votes in the affirmative.
Veach,
Yes.
Walker, Wilson,
Wilson votes yes.
and Doucette.
Doucette votes yes.
Thank you.
Thank you.
Delaney, yes.
Number 10, Senate Bill number 428. The LCO is 3473. It is an act concerning business registrations filed with the Secretary of State. Is there a motion?
So moved.
Moved by Senator Kissel, seconded by Representative Staffstrom. Is there discussion? Representative Fishbein.
Thank you, Mr. Chairman. I'm going to be voting no on this bill today. My first objection has to do with the NAIC code. I still think it should be optional, the disclosure of that code. Unfortunately, that does not appear in this language. Also, and this came up at the public hearing, we have particular portions of this bill before us that generally says, and I quote, "The Secretary of State has the power reasonably necessary to perform the duties required of the Secretary by," and then there's statutory references. I have to presume that there's a intent behind that language. I mean, during the public hearing, it was claimed that it's not necessary, that they're doing stuff anyway. But then it begs the question, then why do you need this legislation? So certainly, I don't know why. There's got to be something that somebody's looking to do that is finding it required that this new language, which appears in, I think, 4 or 5 different spots of the bill before us, all of a suddenly appears, and I'm certainly, well, it's cryptic to me. So I just wanted to explain my no vote. So thank you, Mr. Chairman.
Thank you, Representative. Is there further comment, question on the bill? Further comment or question on the bill? If not, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 428 to JFS it to the floor with LCO 3473. Winfield,
Winfield, in the affirmative.
Staffstrom,
Yes.
Flexer. Quinn,
Yes.
Kissel,
Yeah.
Fishbein,
No.
Blumenthal, Callahan,
Callahan, no.
Conley, Curry, Delaney,
Delaney, yes.
Dillon,
yes,
Doucette,
Doucette, yes.
Jubitsky,
No.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey, Hall, Harding,
No.
Hayes, Howard, Johnson,
but Johnson is yes.
Khan,
Khan is yes.
Labriola, Lesser,
Yes.
Mar,
Mars, yes.
Miller,
Miller is yes.
O'Day,
O'Day, no.
Osborne,
Osborne votes yes.
Havelock D'Amato,
Otto votes no.
Porter,
Porter votes in the affirmative.
Sampson,
Sampson is no.
Sims,
Simpson, yes.
Beach is a no.
Walker, Wilson,
Wilson votes yes.
Elliott,
Elliott, yes.
and Hall.
Can you tell me what bill we're voting on?
Senate Bill 428.
No.
Thank you.
Thank you, Madam Administrator. Number 11, Senate Bill number 439, JFS LCO 3521. Is there a motion? Moved by Representative Fishbein, seconded by Representative Staffstrom. Is there discussion? Representative Fishbein?
Thank you, Mr. Chairman. Mr. Chairman, I move that we move item number 11, SB 439, an act concerning compensation for persons who are wrongfully incarcerated, to the consent calendar.
Been moved. Is there objection? Is there objection? Seeing none. Item number 11, that's Senate Bill number 439, LCO 3521, an act concerning compensation for persons who are wrongfully incarcerated, will be moved to the consent calendar. Number 12, House Bill number 5298, an act clarifying the meaning of sexual intercourse and sexual contact, JFS LCO 3488. Is there a motion? Moved by Representative Gilchrist, seconded by Representative Staffstrom. Is there discussion? Representative Porter.
Thank you, Mr. Chair. I just wanted to state that I will be voting in the negative on this to flag it. There have been some concerns brought to me by the Division of Criminal Justice that questions haven't really been adequately answered for me. So I will keep an eye on this to see if the issues and concerns have been addressed. And if so, I will elect to change my vote. But for today, I will be a negative. Thank you, Mr. Chair.
Thank you, Representative Porter. Further comment or question from members of the committee? Madam Administrator, then please call the roll.
Roll call vote on House Bill 5298 to JFS it to the floor with LCO 3488. Winfield,
Winfield in the affirmative.
Staffstrom, Flexer, Quinn, Kissel, Fishbein, Blumenthal, Callahan,
Callahan, yes.
Conley, Curry, Delaney,
Delaney, yes.
Dillon,
Yes.
Doucette, Dubitsky,
Yes.
Elliott,
Elliot, yes.
Gaston,
Yes.
Gilchrist, Godfrey, Paul,
Yes.
Harding,
Harding, yes.
Hayes, Howard, Johnson, Khan,
Khan, yes.
Labriola, Lesser, Mar, Miller,
Mar, yes.
Miller,
Miller, yes.
O'Day,
O'Day, yes.
Osborne,
Osborne, yes.
Pavlock D'Amato,
Black D'Amato votes yes.
Porter,
Porter votes in the negative.
Sampson,
Sampson is yes.
Sims,
Sims in the affirmative.
Beach. Beach is a yes. Walker, Wilson,
Wilson is a yes.
Blumenthal,
Thank, yep, sorry.
Thank
Thank you, Madam Administrator. Next, we will have item number 13, House Bill number 5325. It's a JFS, it's LCO 3322. Is there a motion? Moved by Representative Quinn, seconded by Representative Fishbein. Is there discussion? Representative Quinn.
Thank you, Mr. Chairman. 5325 is the result of the work of the Injured Employee Partial Permanent Disability Payment Working Group. Initially, what we passed out of the group did contain additional sections to it. However, in discussions with CBIA and the Insurance Association, we came to an agreement to run just this part of it, which will increase the permanent partial disability weeks for a cervical injury to 208 weeks from the 117 weeks that currently are available. And part of what the thought process was there is that many cervical injuries and shoulder injuries really end up being intertwined. So they should be dealt with in the same way in terms of compensating an employee for a resulting disability. I want to thank the folks who worked on this committee, my co-chair, Representative Conley, Attorney Nate Schaffner, Attorney Joe Passaretti, Representative Acker, Attorney Marie Gallo Hall, Attorney Bud Drapo, Attorney Colin Hodnott, Attorney Colette Griffin, Attorney Bill Becker, and Attorney Brooke Foley. It was a very productive group, and none of it would have been possible without the tremendous assistance of our clerk, Nate Kallickman, who did a fantastic job of keeping us on task and creating minutes and agendas in a very timely fashion. So I want to especially thank Nate for his efforts, and also Kirsten, because Nate had to be away a couple of times. So Kirsten helped us out too and was equally as good. And again, thank you to all. And this really resolves an issue that has been an issue in workers' compensation since the major changes went through in 1993.
Thank you. Senator Kissel.
Thank you very much, Chairman Winfield. That was like a floor speech, I would imagine, on the House, thanking everybody for the bill, and it's very apt here at our committee level as well. I mean, obviously, Nathan and Kirsten bless our committee with their hard work, and I want to thank personally Attorney Schaffner for stepping up when I was looking for folks to volunteer to serve on the task force. But it would be remiss of all of us if we didn't thank Representative Quinn for his leadership regarding this. There's a couple of intractable issues, especially as it pertained to workers' compensation, but has ramifications. And he was really methodical in putting together working groups, bringing together all stakeholders, and coming up with this very well-reasoned, rational proposal to move this issue forward to a happy solution. And I think that that is a good model for so many things in this building. So Representative Quinn, take a little bit of a bow yourself as well. I'm happy to support this bill. Thank you, Mr. Chair.
Thank you, Representative Fishbach.
Thank you, Mr. Chairman. You know, we may hear from our municipalities that passing this law, at least out of committee, will increase expenditures. So I just want to, I am supportive of this. I'm supportive of where we are because quite frankly, all we are doing is we are compensating employees who have lost 100% use of their neck. We're going from 114 weeks to 208 weeks is the calculation. When I look at the chart, there are things that, in my opinion, are not as significant of 100% loss of use of your neck that are at 208 weeks. So, you know, ultimately our municipalities pay out on these things at some level, whether they are self-insured or they have some sort of policy that protects them. So certainly rates are going to go up. But at the end of the day, our process is that these individuals who, you know, lose 100% loss of use of their neck and their employment cannot sue in court. Can't get, you know, what others could possibly get if they're not doing it in the employment sphere. So I am totally comfortable with where we are, even though I may hear it from my municipalities. So thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none. Representative Fishbach.
Thank you, Mr. Chairman. Mr. Chairman, I make the motion we move HB 5325, which is item number 13 on our agenda, an act concerning payments and benefits to individuals with partial permanent disabilities, to the consent calendar.
The item has been moved to the consent calendar. Is there objection? Is there objection? Seeing none, the item will be moved to the consent calendar. It's LCO 3322, House Bill number 5325. Number 14, House Bill number 5326, an act concerning factors that the court will consider when deciding whether a restraining order is extended. It's LCO 3549. Is there a motion?
So moved.
Moved by Senator Kissel, seconded by Senator Flexa. Is there discussion? Representative Fishbach.
Thank you, Mr. Chairman. So I do a lot of restraining order work on both sides. And the bill before us has to do with not the initial issuance of a restraining order. It is at the time that the restraining order is perhaps going to go away, whether or not it gets continued. And I will tell you that many times in these restraining order cases, people don't see their children. Many times, I don't want to be stereotypical, but, you know, usually restraining orders are against men. I did have a case years ago where a woman in the middle of the night took an iron on the cord and whipped it around while the gentleman was sleeping and hit him in the head. There was a restraining order over that one. Restraining orders come in various shapes and sizes and various orders. You know, perversely, a few years ago, we passed a law that says you can get a restraining order if you've been coercively controlled. However, we didn't give the court the power to prevent coercive control because we ran to the finish line without looking at the text. If you recall, I voted against that bill. And that's what I hear from judges. Yep, made the finding, but can't prevent it. You guys passed it. It's because the people that pass it don't do these things. What's before us here today is the continuation of restraining order. So let's just say this scenario, mom and dad living at home with 4 kids, and dad, he gets drunk and he says some bad things, and the kids are there. It's inappropriate conduct. His conduct doesn't rise to the level of an arrest, but it gives her concern, mom. So the next day she goes to court and she applies for a restraining order. And maybe that's good faith. Maybe she's legitimately concerned that he's going to do something bad. And the court initially reviews the papers on what's known as an ex parte basis. He's not there. He doesn't know about the application, and determines whether or not the restraining order is going to get issued. And let's just say restraining order issues. And the restraining order is going to put him out of the house more than likely. Shall not threaten, assault, molest, sexually assault, harass. More than likely keep him away from his children. You can't do custody things, integrated custody things in a restraining order application. Within 14 days, he gets a hearing. He gets to say whether or not, or he has his day in court. We'll just call it that. And sometimes guys, taking the stereotypical, continuing on, say, okay, I'll take the time out. It's not worth it. I'll agree to the restraining order. I'll agree. I'll go to counseling. I want my family to stay together. And he agrees to put the restraining order in place for a year. So now he's got to go find a place to live. He's not going to see his kids like he did. But he wants to do good. So he goes to family violence education. Perhaps he hooks up with a therapist. He learns that his activities were inappropriate. And over time, he changes. So now a year has come up. This order's been in place. And what's before the court by motion, because it's not automatic, she, in my scenario, files a motion. Yeah, I feel good. I mean, he's out of the house. I have control. He's not seeing the kids. Well, he's seeing the kids when I want him to. I'm in control of the roost. So I file that motion. I want this to continue on. This restraining order should continue on. So what's before us is, what does the court look at in determining whether or not to continue the restraining order? And what the language says is the fact that a respondent has not violated the existing order shall not preclude extension of such order. So in the scenario I just gave you, he learned that things are bad. He's gone to therapy. He's changed his activity. Yet on the continuation, he gets no credit. What the court should be looking at is whether or not he was electronically stalking her, for instance. Might not rise to the level of a violation or an arrest or something like that, but it's inappropriate activity, restraining order or not. Whether or not he's improperly communicating through a third person. Court should take that into consideration. But the language before us says, nope, if he was good and he has learned and he has done nothing during that period of restraining order, court is not to take that into consideration. The court looks at the subjective analysis of the initial applicant. In my scenario, mom, who's in control of the house, control of access with the kids and things like that. So the language before us says that the court is supposed to look at the severity of the acts that served as grounds for the order. So if there wasn't a hearing and the court took an agreement which many times they do in these cases, they're going by the affidavit, the unchallenged affidavit that's in the file. And it doesn't matter, once again, whether or not he's changed, whether or not something has not happened in the intervening. The other thing is the ongoing impact of such acts on the applicant. So once again, it's the subjective analysis of the original applicant. It is not the respondent and what they have done to get better. There is a way to get this language to a place that is acceptable, in my opinion. You want to look at what he did after the restraining order issued to make the determination on whether or not it should be continued. Because I want dads to be part of their kids' lives. And I want dads to be a good influence on their kids. You know, all too often across this state, we see guys that just say, I'm done. I'm going elsewhere. And who does that hurt the most? It's those kids. And we see those kids. We read about those kids. Not only in the newspaper stealing cars, getting in trouble, we also read about them in the obituaries. And that is not good. Language before us is wholly inappropriate to my position on continuations of restraining orders. And I do intend to vote against and oppose. Thank you.
Thank you, Representative Fishbein. Is there a Representative Howard?
Thank you, Mr. Chairman. Mr. Chairman, I generally just let the ranking member make his points, and I don't normally speak and say that I align my comments with him, but I just feel compelled to here because I've seen the scenario that he just articulated play out far too many times. And I think when we talk about juvenile justice in this committee year after year, I think it's important that whenever possible, children have both their parents in their life. I'll speak for myself. My wife and I parent our kids significantly differently. She generally comes to their defense, and I more often hold them accountable. I think without one or the other, our kids would turn out a bit different, perhaps. And I've seen, and I think we should talk about the fact that restraining orders and protective orders are different. Okay. Protective orders come as a result of an arrest. Restraining orders generally do not. That's something where somebody applies, there's a hearing, and then one is issued. I think the ranking member's point, specifically with the ongoing impact of such acts on the applicant, holds significant water, especially when you talk about the ongoing trauma of domestic violence. So when you have a victim, or in this case, an applicant or a protected party, as they may be on a restraining order, whatever caused them to get that restraining order could have an impact on them for the rest of their life. And I don't think it's appropriate when the respondent has rehabilitated themselves, that because their initial act has had a lasting impact on their victim, or the applicant in this case, that we should remove that person from their children's life forever. And a lot of these protective orders, or excuse me, restraining orders, extend to the minor children. And as the ranking member pointed out, all too often, when these things are applied for and granted, they are used in as tools in civil aspects, and the result of that has a tremendous negative impact on our children. And I have, for 22 years as a police officer, and in the almost 4 years I've been here, worked tirelessly to protect victims of domestic violence, to prevent domestic violence, to put suspects of domestic violence behind bars for the rest of their life. I don't like voting no on anything that has to do with domestic violence or restraining orders. But I think that the concerns raised by the ranking member are very valid. And I will be voting no today. And I really hope that there's careful consideration going forward of what this bill could do to families and children in this state. Thank you, Mr. Chairman.
Thank you, Representative. A comment or question from members of the committee? Representative Osborne.
Thank you, Mr. Chair. And as much as the good representatives on the other side of the aisle would like you to believe that this is a father's rights issue or a children's rights issue, what this really is a victim's rights issue. Nowhere in the language of this bill does this bill require any restraining order to prevent a father from seeing their children. It is one option that is available to a judge when granting a restraining order based on all the facts and circumstances of the case. But what we have right now is a very broad statute that when considering a motion to extend a restraining order after a year, so an entire year has passed and the applicant who's coming to the court is saying that they feel they still need a restraining order of some sort, not necessarily an entire stay away order. They may be asking simply that a non-harass order be put in place. Maybe there is still ongoing litigation that indicates the volatility of the situation might still lead to further issues. And right now, the only guide that we as a legislature have given the court is as the court deems necessary. And what that incredibly broad language has done is result in there being literally no guidelines or standard for a judge to follow. So if you end up with a judge who has very limited family law experience, or who has a particular worldview, or who is worried about custody situations or whether it's being appropriately applied for or not, you end up with entirely different results from judge to judge to judge, depending upon that judge's worldview. So all this bill does is say, hey, Your Honor, here are some criteria we want you to consider. Doesn't mean you have to give more weight to any of these factors than any of the others. We're asking that you consider the severity, and on the flip side, the lack thereof. We consider the impact on the victim, because yes, actions have consequences. And if the action taken by the respondent has traumatized the victim or the applicant to the point where exposure in that particular instance, based on all the facts and the circumstances of the case, would be traumatic, further traumatic, given everything else happening in the case at that moment in time, this allows the court to consider that appropriately, especially since the coercive control aspects of this of the domestic violence were put into place. So all this does is provide some guidelines and some criteria to the judges who are hearing these applications for extension to give them a map on what they should be considering. It doesn't tell them to weigh one factor more heavily than another. It just says these are the types of things you should be looking at and considering in making that decision. Through you, Mr. Chair.
Thank you, Representative. Comment or question from other members of the committee? Comment or question from other members of the committee? Seeing none, Madam Administrator, please call the roll.
Roll call vote on House Bill 5326 to JFS it to the floor with LCO 3549. Winfield,
Winfield, affirmative.
Staffstrom, Flexer,
Yes.
Quinn,
Yes.
Kissel, Fishbein, Blumenthal, Callahan,
Callahan, no.
Conley, Curry, Delaney,
Delaney, yes.
Dillon,
Dylan, yes.
Doucette, Dubitsky,
No.
Elliott,
Elliot, yes.
Gaston,
Yes.
Gilchrist, Godfrey, Paul,
Yes.
Harding, Hayes, Howard, Johnson,
Johnson is yes.
Khan, Labriola, Lesser, Mar,
yes.
Miller,
Miller, yes.
O'Day,
O'Day, no.
Osborne,
Osborne, yes.
Havelock D'Amato, Porter,
Porter votes in the affirmative.
Sampson,
Sampson is yes.
Sims,
Sims,
Beach?
yes.
Beach,
Sims,
Beach is-
yes.
Walker,
Walker votes in the affirmative.
Wilson,
Wilson votes yes.
Doucette,
Doucette, yes.
Thank you, Madam Administrator. We'll move to item number 16, House Bill number 5381. Not concerning the use of police body worn equipment. It's just a straight JF. Just moved by Representative Stastrom, seconded by Representative Fishbine. Representative Fishbine.
Mr. Chairman, I make a motion, we move item number 16 and act concerning the use of police body worn recording equipment to the consent calendar.
It's been moved to the consent calendar as objection. Is there objection? Seeing none, this item, House Bill number 5381, will be moved to the consent calendar. With that, Madam Administrator, could you read the items on the consent calendar and then call a roll?
consent calendar is consisting of Senate Bill 272, House Bill 5421, House Bill 5466, House Bill 5487, House Bill 5500, House Bill 5505, Senate Bill 360, Senate Bill 439, House Bill 5325, and House Bill 5381. Winfield.
Winfield, and it,
It's okay. 360. 439.
Winfield in the affirmative.
Staffstrom,
Yes.
Flexer, Quinn,
Yes.
Kissel,
Yes.
Fishbein, Blumenthal, Callahan,
Callahan, yes.
Conley, Curry, Delaney,
Delaney, yes.
Dillon,
Dylan, yes.
Doucette,
Doucette, yes.
Rubitsky,
Yes.
Elliott,
Elliott, yes.
Gaston,
Yes.
Gilchrist, Godfrey, Paul,
Yes.
Harding, Hayes, Howard, Johnson,
Yes.
Khan, Labriola, Lesser,
Yes.
Mar,
Mar, yes.
Miller,
Miller, yes.
O'Day,
Yes.
Osborne,
Yes.
Havelock Tomato, Porter, Sampson,
Sampson is yes.
Sims,
Simpson, affirmative.
Beach. Yes. Walker,
Walker votes in the affirmative.
Wilson,
Wilson votes yes.
The votes will remain open until 5:30, and the committee will meet again Monday at 10 a.m. Until that point, until 5:30, we'll be in recess. Thank you all for joining us today. Happy Easter, Passover, whatever days you're celebrating.
There we go. Very good.
Whatever days you're celebrating.
Can you guys hear me okay?
Yep, we can hear you.
Yeah, we can. Thank you,
Okay,
Kristen.
excellent. Okay, so, Representative Hall,
Yes, ma'am.
um, for Senate Bill 324, how would you like to vote?
324 would be no.
Okay, for 350,
Yes.
for 54, hang on, in order, 425,
425 is a no.
426,
426 is a yes.
okay. We can have, how about 54, oh, it's gonna be 5414.
50, what was the number? I'm sorry.
That's okay, 5414.
5414 is a no.
And then 5467.
5467 is a yes.
67 is a yes. Okay, great. All right, you're all set.
Great, thank you so much.
Thank you.
Bye-bye.
Senator Sampson,
Good evening. Thank you.
how are you? For Senate Bill 4,
Senate Bill 4, which was number 1, I am a no.
for 209,
I am a no.
for 324,
324 was item number 4, I am a no.
350,
Number 350, I am a yes.
425,
That was number 8, I am a no.
426. I have you as a no. 428. Got you.
That's about what I
Um,
came
And then 5414,
in. 5414 is 17, and I am a no.
and then 5467.
21, I am a yes.
Okay, and I've got you for consent. You're all set.
Awesome. Thanks so much.
Thank you, Senator. Have a good weekend.
You.
Representative Dillon.
Yes, ma'am.
I believe you are all set. I can just double check real quick for you. Yeah, you're all set. You're good.
Terrific. Thank you very much.
Have a good weekend, of course. Senator Gaston.
Yes, I just want to make sure that I'm all set. I may have missed one in the very beginning.
Yeah, I missed you on Senate Bill 4.
Yes.
Okay, and I have you on consent. You're all set.
Thank you so much.
Have a good weekend.
You too.
Representative Wilson.
Hello. Yeah, I think I only missed a few.
I only have you as missing 5414, but I can check the others as well for you.
That's a yes.
Okay.
I think that might be the only one.
Yeah, I think that was the only one I had written down for you.
Because that was the one
Yep,
with
you're all set.
several amendments.
That's right. Yep, I've got you everywhere
All right.
else.
All right. Thank you. You have a good weekend.
You too. Enjoy. Representative Elliott.
I'm here.
There you go. Awesome. Senate Bill 4,
Yes.
Senate Bill 209,
Yes.
324,
Yep.
350,
Yep.
425. I got you. 254, 14. I think it's gonna be the next one. Yep, 5414,
Yes.
and then 5467.
Yes.
I have you for consent. You're all set. Have a good weekend.
Thank you, Kirsten.
Senator Harding. Can you hear me okay? Your audio is breaking up a little bit. I don't know if you. It's broken up. It's just, it's like laggy.
Hello, can you hear me?
Oh, that's much better. Yep.
Yeah, I can hear you now.
Perfect.
Yep.
Okay. Senate Bill 4.
Sorry, it's like the
No,
worst spot you got me on.
that's
Can you
okay.
hear me now?
We got you. Yep. Can you hear me okay?
Hello?
Can you hear me? You there?
I
You
can
froze.
can you go back to me, I
Yeah.
guess?
Yeah. All right. I'll come back
Yeah,
to you.
I'm in one bad spot
That's okay.
right now.
Representative Labriola.
Oh, good. All right, good. Senate Bill 4, I'm a no. Yeah, I can hear you fine. Senate Bill 4, I'm a no. Yes, I can hear you fine. Did you want to do me or are you going to
Yeah,
finish with
there you
Steve?
go. I think he got bumped. So we'll go Representative Labriola if you are ready.
I am ready.
Senate Bill 4.
Is a no.
Okay. 209,
No.
324,
No.
350,
Yes.
425,
No.
426,
Yes.
428,
No.
5298,
Yes.
5326,
No.
5414,
No.
and the 5467,
Yes.
and the consent calendar.
Yes.
All right, awesome. You're all set. Thank you so much, Representative.
Thank you. Take care. Bye-bye.
Have a good weekend.
You too.
Just give me 1 second. Representative Delaney.
Hello, Madam Administrator.
How are you?
Good. Am I recorded as missing any votes?
Not that I have you down for. Let me just double check for you. Nope, you're all set.
All right, roger that. Thank you, Madam Administrator. I hope you have a wonderful weekend.
You too. Enjoy.
Goodbye.
Representative Doucette.
Almost done.
I know, we're so close. For Senate Bill 324.
Yes.
Okay. For Senate Bill 350.
Yes.
For 5414.
question on that one. Were there any amendments that were adopted
No,
to
we just
the
had the
JFS?
JFS
No.
language, right?
Okay.
Yeah, nothing was adopted.
Okay, so I vote yes on the bill.
And then the last one is 52. I think it's 5298.
Yes.
Yep. Okay. All right. And then got you for consent. You're all set.
Okay, great. Thanks.
Thank you
Have a
so
good
much.
weekend.
You too. Enjoy.
Bye.
Senator Harding?
Can you hear me now?
Yeah,
Hopefully
perfect.
this time it works.
Okay.
All right, good. Sorry about that.
No worries. Okay, so for Senate Bill 4, I had you down as a no. Is that correct?
That is correct. Senate Bill
Okay.
4 is a no.
That's the only one I was able to hear. Okay, so for 209.
Gotcha. 209. 1 second. I'm a no for 209.
Okie doke. For Senate Bill 324.
I'm a no for 324.
For 350.
Yes.
For, let's see. So the next one should be 5326.
Yes.
5414.
Yes.
5467.
Yes.
And the consent calendar.
Yes.
You're all set. That's everything.
Thanks, Kirsten. Appreciate it.
Awesome.
Have a good weekend. Yeah, bye.
Can I just vote on the consent calendar?
Yeah, absolutely.
I don't have time for anything else, sorry.
Okay, I missed you on 3. I can just tell you the numbers if it matters. Otherwise, go ahead.
Well, if it's number 3, yes, and then consent calendar, yes.
Okay, so for 3, a yes. 3 was on consent.
Okay, yeah, then, yeah.
Do you want to, so nothing, the others, you don't mind?
Yeah, I'm in a meeting, so I got to get back to it.
No worries. Okay.
Thank you.
Thank you. No.